Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and we are back again for another episode of the FCPA Compliance Report. Today I have with me James Koukios. James is a partner in Morrison Foerster, and we take a deep dive into some of the significant FCPA cases, information, and events which took place over the summer of 2017. We consider the CocaCola case and what it means for the compliance practitioner, and does it change the calculus around self-disclosures. We take a deep dive into declinations with disgorgement and what that might mean for companies going forward. We also consider the DOJ's role in anti-kleptocracy efforts, in forfeiture complaints around ill-gotten gains of bribery. We take a look at the Halliburton enforcement action, also some declinations without disgorgement that were issued. We consider the sentencing of Dmitri Harder and what it might mean. We consider the Forex case in the context of compelled testimony and what this may mean for FCPA enforcement going forward. We consider the undercover investigation regarding the U.S. Army colonel who is charged with conspiring to bribe Haiti officials, and explain how undercover operations work in the context of FCPA enforcement action. We conclude by taking a look at the UK Financial Reporting Council recent announcement of its plans to require increased anti-corruption and anti-bribery disclosures and what that might mean for U.S. corporations. It's a fascinating episode. James is one of the top-notch FCPA and white-collar defense lawyers in Washington. The Morrison and Foerster newsletter around international anti-corruption is one of the great resources. It comes out on a monthly basis. I will link to it in the show notes. This episode is a little bit longer than usual as we had a lot to catch up on. So sit down, strap in for a great ride on what's been happening over the FCPA world in the past 3 months. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello everyone, Tom Fox, back again for another episode of the FCPA Compliance Report. I am thrilled today because I'm going to have a ton of fun speaking with my good friend and colleague James Koukios. James, of course, is a partner at Morrison Foerster, whose firm puts out an excellent monthly newsletter on top 10 international anti-corruption developments. We've missed a couple of months, so we've decided to, in this episode, put in the last 3 months of the firm's newsletters, June, July, and August, and it's going to give us a really great chance to talk about events over a 3-month period and really geek out, because James and I just have that gene in us. So, James, with that, thanks for taking the time, and you got a lot of stuff in these newsletters, so how about we just jump right into it?
Sounds great, Tom.
So we started off back in June with really one of the most significant, certainly Supreme Court cases that has FCPA implications, and that's the CocaCola case. And I don't want to really take too deep a dive into the facts because we could spend an hour just geeking out on it. But I just wondered if you might be able to summarize the result of the ruling, and then maybe we can explore what does it mean for the compliance practitioner, you as a defense lawyer advising companies about self-disclosure, and does it change the calculus at all?
Sure, Tom. So the issue presented by CocaCola to the Supreme Court was whether disgorgement was a penalty within the meaning of 28 U.S.C. Section 2462, which is the statute of limitations for suits brought by the government to enforce any civil fine, penalty, or forfeiture. For years and years and years, the SEC has taken the position that disgorgement is an equitable remedy and that it doesn't fit within the language of Section 2462. In fact, if you go back and look at the FCPA enforcement guide that SEC and DOJ put out in 2012, that's actually in there. The SEC says disgorgement is an equitable remedy. It's hard to say. That's not subject to the statute of limitations. And practically speaking, what that meant was the SEC could make an argument that even if CocaCola was not an FCPA scheme, but to put it in the FCPA context, even if a bribe was paid in 1995 and the enforcement action was being brought in 2017, they could go all the way back to 1995 and disgorge illicit profits from 1995 to present. Most appellate courts had actually agreed with the SEC, but the 11th Circuit a couple years ago disagreed and actually May of last year disagreed, created a circuit split, and the Supreme Court took it up. And the Supreme Court actually ended up agreeing with the 11th Circuit, in effect, that disgorgement is a penalty within the meaning of the statute of limitations statute, and therefore the SEC was limited to the 5 years to go back to get disgorgement. This is obviously has the potentially significant impact on the SEC's ability to get disgorgement FCPA schemes. As you know, and your listeners know well, oftentimes foreign bribery is not detected for many years after it takes place. So you've already lost a fairly significant part of the statute of limitations by the time you find out about it. And then by the time you finish investigating it, it could be even past that as well. So that's a potentially significant development in the SEC's ability to bring one of its favorite forms of remedy in FCPA cases.
So I guess the thing I've been struggling with, James, is does this change the calculus on whether or not to self-disclose? And if you have a case where the bribery happened 4+ years ago, does CocaCola impact your decision if you have moved ahead to investigate and remediate to a level that's satisfactory to someone like perhaps yourself or even someone like myself? But then if you're going to not have to pay you're not going to have to disgorge profits after 5 years, does that, you think, in any way change the calculus?
I do think it's another factor that a company has to take into consideration when making the determination about whether to self-disclose. If it's a company that's also subject to DOJ jurisdiction, or if it's better said, an offense that may be subject to DOJ FCPA jurisdiction, it may not matter that much because, of course, DOJ has other theories that can extend the statute of limitations. So, for example, conspiracy. If they find that the conspiracy went back to 1995, they could still impose penalties and forfeiture and things like that through the court going back to 1995. There's a conspiracy. So it may not be the only thing to consider, but I certainly do think it opens up several new defenses and new factors to consider for a company, especially a publicly traded one, when making that calculus about whether to self-disclose. I also think if you find yourself in front of the enforcement authorities, whether voluntarily or involuntarily, it also does maybe open up some new avenues for negotiating position. The disgorgement amount always is kind of a back and forth between the SEC and the company. What is an illicit profit? How should profits be calculated? Which transactions were actually tainted by a bribe and so should be included in the pot from which illicit profits are calculated? That's not always a black and white question. That's oftentimes subject to negotiation between the agencies and the company. And so I think this may, give companies another sort of tool in the toolkit to argue, disgorgement should be lower. You shouldn't pursue this penalty because it's past your statute of limitations, things like that. I think what we'll see is SEC will I'm sure they read Supreme Court cases too. I have no doubt about that. So I'm sure they've already thought about how they're going to address this. My guess is that they will. They already do, for the most part, most cases ask for tolling agreements, but I think this would enhance their desire to enter into tolling agreements early in the case. They, of course, are not limited to disgorgement. They can also bring civil penalties, and they could say, okay, if you don't agree to disgorgement going back to 2000, we're going to impose a civil penalty on you anyway, so you might as well agree to it. And I think a lot of times when disgorgement comes into play, it's, these are oftentimes negotiated settlements. And so as part of the negotiation, a company can waive its statute of limitations defenses. It's an affirmative defense. So they can agree not to pursue it in order to get a negotiated resolution. So, but I do think that it's a significant development. And I think it does give defendants a lot more bargaining power and potential avenues to challenge actions by the government as a result.
James, we also had a couple of, I thought, very interesting cases that are now under the rubric of declinations with disgorgement. They came in under the FCPA pilot program. The first was Lindy Gas, and the second was CDM Smith. And I was wondering maybe what your thoughts might be on these cases, and then also what does this mean for companies going forward in the context of the pilot program?
Sure. Well, one big question of going forward with the pilot program is, would it last past its expiration date of April 2017? The pilot program came out in April of 2016, and it said it was going to be in place for 1 year. Big question about whether that was going to get renewed. The acting assistant attorney general for the criminal division, Ken Blanco, who was one of my first bosses when I was in AUSA in Miami, said that they were going to keep it in place while they reevaluated it. And so apparently that reevaluation period is still underway. It'll be interesting to see what happens to the pilot program once the permanent AAG is confirmed and in place, whether it'll keep going or not. But at least for now, the pilot program is still alive and well, and DOJ is still using the one of the planks of the pilot program, announced in the pilot program, declinations with disgorgements, to resolve certain cases that meet the criteria of that. So declinations of disgorgements, in my opinion, is probably the biggest impact that came out of the FCPA pilot program. You can argue that maybe some of the definiteness of 25% off for cooperation, 25% off for self-disclosure was a big factor, and maybe it was, but I think DOJ was already doing a pretty good job of articulating those kind of things before. The big thing to me was declinations with disgorgements, because DOJ had not pursued that type of resolution before. And so we see with these two cases that you mentioned, Tom, Lindy and CDM Smith, that DOJ can apparently, at least for the near future, is still intent on using that as a fourth way of resolving cases, either by straight out declinations, NPAs or DPAs, or a guilty plea, and now we've got declinations with disgorgements. I think there's a lot of debate about whether declinations with disgorgements encourage or discourage companies to come forward and self-report. My own opinion is that it acts on net as a disincentive, because unlike Morgan Stanley, which was able to get a complete declination, not have to pay any penalties or disgorgement at all, because they had such a fantastic compliance program, such fantastic cooperation. The declination with disgorgement basically says, even if you do everything right, we're going to make you pay money. And that's not really the worst part. The worst part is, and we're going to make it public. There's no longer, Morgan Stanley, of course, was not a silent declination, but many other declinations, discretionary declinations, had been silent. And so a company could come forward, disclose, do everything right, and then not bear the sort of reputational hit of this. But now with declinations with disgorgements, DOJ actually publishes the letters that it sends to the companies on its website, makes it public, basically says, we believe you committed a crime, but you're a good corporate citizen otherwise, so you have to pay money and we're going to decline. So I think when you consider that sort of reputational hit there, it tends to act as a disincentive for companies to come forward. But I suppose if you're a company that is in a position of you're going to have to resolve with DOJ anyway, that's going to be a more preferable solution, because it has no undertakings as compared to an NPA or a DPA, which has a reporting period, has a number of undertakings that you have to go through, which can cost a lot of money and things like that.
Well, I guess, James, what I would see with the difference in a declination like Morgan Stanley, which was public, or some of the private declinations, vis-a-vis the declinations with disgorgement under the pilot program, is that certainly with Morgan Stanley, there was a best practices compliance program in place at the time of the facts that led to the incident in question. And as I read the declinations with disgorgement over the past 15 to 18 months, what I have not seen is a best practices compliance program in place at the time of the incident. Now, there was extensive remediation, and remediation enough to meet the requirements under the pilot program. But what I didn't see discussed was the status of the program at the time of the incident in question. And that, to me, really spells out the difference between either a private declination or a declination without disgorgement and a declination with disgorgement under the pilot program.
That's a fair point, Tom. I think, one thing is that the summary of the conduct and sort of the factors that were involved in the declinations of disgorgement are pretty brief. So I don't know if we can necessarily infer that there weren't good remediation programs. That may certainly be the case, and you may be onto something. But they're a little bit sparse in some of their reasonings, and they tend to emphasize instead those other things like self-disclosure, cooperation, and remediation, as opposed to the other 7 Philip factors that could be considered. They really focus on those sort of 3 post-discovery mitigation factors instead of the pre-discovery factors.
Right. Next up, James, we had a civil forfeiture complaint filed in connection with the 1MDB scandal out of Malaysia. And we have briefly touched upon the Anti-Kleptocracy Act, civil forfeiture in some of our prior podcasts. But in the context of this, I was wondering if you might be able to explain to us, how does such a forfeiture work in conjunction with the type of FCPA enforcement you're most familiar with, and perhaps the listeners are more familiar with?
Sure. So I'll use a couple terms that we use in the U.S. Our European colleagues use different terms. Of course, we call it here supply side and demand side of bribery. Supply side being the companies and individuals who pay bribes, and the demand side being the officials who demand them. Our friends in Europe and elsewhere in their world call those active and passive bribery, but I like the supply and demand side rubric better. The FCPA is a supply side statute. As you know, and your listeners I'm sure know, it does not allow for charging foreign officials who accept bribes or solicit bribes to be charged under the FCPA. So it really does focus on the bribe payers, the supply side. But that leaves an obvious hole in anti-bribery enforcement. If you can only focus on the supply side, what is going to be in place to try to reduce the demand side? And the anti-kleptocracy program that the money laundering and asset recovery section of DOJ runs is really focused on that demand side. It's basically saying if you are a kleptocrat and you have brought your money into the United States, or your stolen assets into the United States, we are going to seize that, forfeit it, and repatriate it so that you cannot benefit from it. And that's really it's kind of trying to round out FCPA enforcement or anti-bribery enforcement by focusing on that demand side. We've, of course, seen the FCPA unit use other tools like money laundering charges and Travel Act charges to sometimes prosecute foreign officials as well. But this is really, the anti-kleptocracy program is really specifically focused on that demand side of trying to make sure that a kleptocrat will not benefit from being corrupt. And so in this case, the allegations are, as you said, it's involved with the Malaysian Development Fund, that some of the money was moved into the United States, and DOJ went after it to try to forfeit it. And together with another forfeiture action that was filed last year in the same case, it's the largest action ever brought by the kleptocracy program.
Well, I think that's going to be a very interesting tool. I really appreciate your supply side and demand side dichotomy, and I think most, at least U.S. listeners, understand that, and to give prosecutors another tool to help fight really the worldwide scourge of bribery and corruption. If we could now maybe turn to July, and I think most listeners would think about the a SEC actually enforcement action that came out towards the end of July involving the Houston-based company Halliburton as one of the most significant cases. But in that case, I've podcast and written quite a bit about it, but I wanted to focus on one point with you, James, and that's the following. In that case, Halliburton was required, I can't remember if it was legally or contractually, to have a local content partner. And I've thought long and hard about when that's required either by law or in a contract with a state-owned enterprise or a foreign government. Is a local content partner different than a sales agent or an agent on the sales side, or are they different from a vendor who comes in on the supply side? Do we need to create a different category of third party for either due diligence or post-contract management purposes, or do you just see that as really falling into one of those two categories?
No, it's a great point, Tom. I mean, local content is, in theory, makes a lot of sense. If you're a resource-rich country that doesn't have a lot of technology and you have a lot of foreign companies coming in and taking your resources, the theory behind local content is we need to keep more of that at home, and we need to develop our own infrastructure, whether it be personnel-based or technology-based or expertise-based, so that we can benefit more in the long term for having our these resources. And so in places like Angola, where they have a lot of oil, but they don't necessarily have all the technology or education, the idea is we want to develop our own people and our own industries so that we benefit from these things more long term, even when the oil is gone. And so in theory, they're good programs. The problem is the devil's in the details, and these countries are oftentimes very low ranked in the CPI index, and they're very corrupt and things like that. And so you introduce potential issues with, especially if there's a small elite, there's not a lot of people who can provide services. Do you end up having as your local content provider somebody who's politically exposed or connected? And so you raise a good point. I think one thing that the SEC pointed out, in particular in the Halliburton opinion, was allegedly the person at the company who was responsible for selecting the local content partner actually specifically looked for, they kind of backed into, they picked the person to provide the services first and then backed into the services they would provide. And the allegations were that the person at the company responsible for that picked services that would not fall within enhanced due diligence or anti-bribery scrutiny. He actually went and tried to find a vendor service that was kind of a lower risk. That presents a lot of challenges to a risk-based compliance system, which DOJ and SEC have long said you should pursue. Your caterers or your travel agent, well, not travel agent is a bad example, but some of your chauffeurs, things like that, you would think ordinarily in a risk-based system, it would make sense to have them be lower risk, subject to lower due diligence scrutiny. But exactly your point, Tom, if it's a local content provider, if there's a small number of people and they may be politically connected, does it make sense to apply that rubric to them just because in other countries the services they're providing would be considered low risk? And so it may be, given the fact that it's a sort of a government mandated program, maybe there should be a third category where local content is an additional risk factor that's added into your program that may require you to do enhanced due diligence on a vendor that would otherwise be low risk in another country. So I think you raise an excellent point. It's kind of a conundrum for the oil industry, for the defense industry, for a lot of companies that operate in places where you're supposed to be good corporate citizens and engage in local content type activities. What kind of additional risk might that provide, and how should a good compliance program, a risk-based compliance program, factor that in?
And I guess I see that really leading to the need for a discussion between your compliance function and your corporate social responsibility officer or whoever in the company might be kind of heading up that effort and really thinking through it on a risk-based or other approach. So I think we're going to have to watch that one going forward and see how that develops, James.
Definitely true. And I think it has larger applications as well, as more and more employees become used to risk-based compliance programs and understand the limitations. Are you going to get your rogue employee who's going to do things like pick vendors who they know won't get scrutinized, even outside of this? And what do you do about that? It's kind of like employees who may divide up invoices to make sure they keep under a monetary threshold and things like that. So maybe there's also some way some creative compliance officer can also figure out when employees may be employing this type of circumvention strategy as well. But it really does pose challenges to risk-based programs, and I don't think DOJ or SEC would back off their belief and their gospel that risk-based is the way to go. So just the ever-evolving compliance environment.
Yes. Next, there were three long-standing corporate FCPA investigations ended without charges or I would say declinations issued. One was to IBM, the second to Net1 UPS Technology, and the third to Newton Mining Corporation. I must say, in your newsletter, the MoFo newsletter, had as much information on them as I've seen in one place. So just not very much information, but as is typical with a private declination. But I was wondering if you would have any ideas does this provide any information to the compliance practitioner, or are you able to use any of these declinations in advising any of your clients?
Well, the only reason we really know about these is because there are three publicly traded companies who had previously disclosed that they're under investigation in their securities filing, and so understandably then disclosed in their securities filings that they were no longer under investigation and that they had those investigations had ended with no charges. There's not really much that can be gleaned from them. DOJ doesn't comment on them. They don't provide any explanation generally for why they decline these cases. I think one thing and the reason we include it in our newsletter is it does show that there are still possibilities to get declinations straight out, not a declination with disgorgement, but just a declination. In my experience, and I'm not commenting on these three cases in particular, but oftentimes those cases may be the prosecutor may decide that no violation occurred. They may have concluded that a violation occurred, but it's beyond the statute of limitations. They may have concluded that a violation probably occurred, but we can't prove it beyond a reasonable doubt if we had to be put to our burden of proof. There could be other things too, like great cooperation, self-disclosures, things like that, but maybe just different from the pilot program. So it's a little hard to draw a whole lot of conclusions from these. I think as a collective whole, we can just draw a conclusion that straight out declinations still sometimes do happen.
So we had a sentencing, I thought a very interesting sentencing of Dmitri Harder, who had pled guilty back in April of 2016 to FCPA violations for his role in bribing a senior official at the European Bank for Reconstruction and Development. And he received a 5-year sentence. Were you able to really kind of ascertain the basis of this sentence? And did you find anything about the sentencing unusual, or does it seem to be kind of right along the lines of what the sentencing guidelines would lay out?
Yeah, if you look at the public record here, Harder was not your traditional cooperator. He did not start cooperating early on. He did not cooperate from the beginning. If you look at all of the public record, he filed lots of motions. He first of all, he got indicted. So oftentimes if somebody starts cooperating pre-charge, it's an information with a plea agreement. He was indicted, so he wasn't cooperating, at least according to the public record, pre-charge. Then after being charged, his attorneys filed a bunch of motions. At one point, the judge actually yelled at the attorney and said, you're filing all these motions, they're baseless. And the judge sort of encouraged him not to file anymore. So he didn't cooperate for a long time after being charged. He finally lost some pretty significant motions along the way and then decided to plead guilty at that point. So it wasn't really the type of defendant that you would ordinarily think of getting a break from a sentencing judge or from DOJ in that. But at the very end, Harder did decide to cooperate, and he ended up testifying by video conference in the trial in the UK of the official that he allegedly bribed. So Harder was a Philadelphia-based business person who worked with the European Reconstruction Bank, one of the multilateral banks over there. And the allegations were that he and this official conspired to give various business opportunities from the EBRD. And so Harder ended up post-guilty plea testifying by video conference against Ryzhenko, who was the EBRD official. The EBRD official was convicted and got 6 years imprisonment in the UK, which seems like a pretty significant sentence on its own. And so Harder's argument at sentencing was, I cooperated. This guy got 6 years. I should get significantly less. And I think DOJ and the judge, in my experience, not surprisingly said, look, you cooperated, you get some benefit for that cooperation, but you didn't do quite enough to get an extraordinary amount of time off. So basically what happened was the sentencing guidelines came out to around 7 to 9 years. DOJ did ask for a reduction in sentence to 57 to 71 months, reflecting Harder's cooperation. And the judge did indeed sentence him within that range to 60 months. So Harder's attorney, apparently kind of a colorful character, was very unhappy with that, thought his client should have gotten 2 years since he cooperated, and since the official himself got 6 years. But I think that the sentence itself, if you talk to a lot of defense attorneys or prosecutors, pretty understandable under the circumstances. I will say, however, 5 years is a pretty significant sentence, especially in the FCPA. Of course, we had the longest sentence ever was 15 years with Joel Eskenazi in Miami, which is the case I prosecuted. We had my last case I prosecuted was actually the DAP case, and one of the defendants who pled guilty there got 4 years, which is a pretty good sentence as well. So 5 years is a pretty significant sentence. I can't disagree with Harder's attorney in that way. But I think under the circumstances, it does send a message. I think the judge wanted to send a message that Harder's conduct, as alleged, was fairly blatant, and Harder took a long time before he kind of came around and accepted that. So I do think if you're a compliance officer or somebody who does training in this area, this might be one of those good examples to tell people about the FCPA. Violation of the FCPA does have real world consequences, and you can go to jail for a significant amount of time.
And then I would like to end the kind of July discussion with something I've really been saving up and wanted to talk to you about. And that is a case that came out where the Second Circuit overturned the conviction of two former bank traders who were charged with manipulating the LIBOR rate. The sentences were overturned, as I understood it, because their testimony was compelled to the UK's Financial Conduct Authority, and it was used against them in trial. I've used the term compelled testimony. And the reason I really wanted to talk about this with you, James, is I see a lot of implications for FCPA international cooperation and indeed enforcement. And so I guess the first question I would put to you, do you see the same implications? And if so, or if not, are my fears misplaced?
Yes, this is one of being involved in multinational law enforcement efforts is extremely complicated. It's much easier when you're just dealing with the United States and you have U.S. law to apply. When you're dealing with these multilateral and multinational investigations, it's so complicated because of all the different laws throughout the world, and what may be legal in one country may not be legal in another. And that's what happened in this case. In the UK, you can compel testimony. Certain agencies can compel testimony, and it's perfectly legal. But in the United States, obviously, compelled testimony is a problem. And just to quote the Second Circuit, because I think it's a very erudite quote that gets to the heart of the ruling, the court held, quote, "The Fifth Amendment's prohibition on the use of compelled testimony in American criminal proceedings applies even when a foreign sovereign has compelled the testimony." So what happened in that case was really before the U.S. could act, UK authorities compelled some testimony. And that testimony was made available to a witness that eventually testified in a U.S. court against two defendants in the U.S. court. DOJ had taken the position, look, that wasn't our fault. And we took steps to try to segregate the impact of exposure to compelled testimony on these folks. And they did a very elaborate brief. Judge Rakoff, who was the trial judge, agreed with DOJ. Very interesting opinion. I mean, I think one thing that really struck me in the lower court opinion was how much care DOJ did take to try to prevent this problem that they didn't create. And it convinced Rakoff, but it didn't convince the Second Circuit. I think the one thing that, this was kind of early days in LIBOR and FX. when this happened, there was certainly a history of law enforcement cooperation between the UK and the US, but it sort of wasn't this sophisticated or this detailed at that point. I do think that at this point, both US prosecutors and UK prosecutors are much more attuned to these types of issues. And so they start talking about these things much earlier on, and they start working together in a way, not necessarily coordinating, but coordinating in some sense to try to avoid these problems. There'll be an open discussion. Can we compel this or not? Should we compel this or not? Can we, what can we do to make this case be admissible in both the UK court and the US court? It's not unlike how the DOJ and SEC learned over the years how to cooperate together because of the different standards and the different rights that are implicated between civil and criminal prosecutions. That is now being extended to UK and the US. And so I think, Tom, your fears are grounded. I think the thing that should mitigate your fears somewhat is that DOJ and the UK are doing a very good job of trying to work these problems out ahead of time so it doesn't happen again. Indeed, I think we may have talked about in an earlier recording that a DOJ FCPA unit supervisor is now on detail over at the SFO and FCA to try to, continue to this dialogue and to learn from each other. So there's definitely a lot of effort being put into place to avoid these problems from happening again. But it could still happen with the UK. And if you're dealing with other countries, it could happen again because you don't have that sort of long history that the UK and the US has. So I do think this is a very important issue. It definitely poses challenges to international law enforcement efforts. But the good news is I think that, as I said, agencies are becoming much more attuned to this, and they're starting to work these out so people's rights are respected in multiple jurisdictions, and this won't happen quite like it did in this case.
Well, that's of some comfort, but I'm going to watch this one, and but maybe actually with the way you frame that, James, that it really perhaps the opinion does give guidance to prosecutors and helps them to understand what they can and can't do, or what the courts will allow or perhaps not allow, so that they can craft their investigations to follow really the court prescriptions therein.
Yes, agreed.
Well, let's turn to August now. And in there, I just wanted to highlight a couple of things. The first was that following an undercover investigation, the Department of Justice charged a retired U.S. Army colonel with conspiring to bribe Haitian officials. And the reason I wanted to bring this up is, from the prosecutor's perspective, is this one of the arrows that is in your quiver? Is this something that you would only utilize on a very rare basis when something basically falls into your lap? Or how does something like this get started? Yeah,
so DOJ has said for years that they would use whatever law enforcement techniques were available to them in FCPA cases. The most significant example we saw of that was the Africa sting case, which was using undercovers and a sting operation to do that. Of course, that didn't end very well, but it did show that DOJ was willing to use that. We've only seen one other wiretap case in an FCPA case made public, which was the Sillins case, where a representative of a mining company who allegedly paid bribes to African official for mining rights came to the United States and was allegedly trying to pay off the wife of the official, and that led to a series of recorded meetings and then ultimately a wiretap. So I think that what the Baptiste case shows is that DOJ was not scared off by what happened in the Africa sting case. They continue to want to find the appropriate cases to bring wiretaps and to use undercover techniques, and that they can and will do that. So I think the Baptiste case is a nice reminder for folks if they thought that DOJ had sort of left some tools behind, that in fact they are going to keep going and trying to use those. Now, you asked about wiretaps. Wiretaps are very difficult to get in any kind of case for good reasons. They're quite intrusive into people's privacies. You have to do a Title III application to a judge, and it has enhanced protections and things like that. It's very hard to get. And FCPA cases can be very difficult to get because oftentimes the conduct is historical. It's already happened, and you're sort of just investigating what happened in the past. if a bribe scheme is actively going on, it's oftentimes not taking place in the United States. And so it may be very difficult to get a wiretap because of that, because all the conduct is happening overseas. And so the Baptiste case really it was a fellow who lived in Maryland who was going to Boston, U.S. phones, U.S. conduct, and they were able to ongoing. And so they were able to get that wiretap and do some undercover recordings in that case.
Well, I found it a fascinating example that the DOJ will use all of the tools and to hopefully remind people that really the whole panoply of white-collar enforcement and criminal enforcement techniques are available to the Department of Justice, which they will use when appropriate.
Yes.
So there's one other thing I wanted to raise, and I realize it may be a little bit out of your normal remit or the practice you engage in, but I was very intrigued with one of the entries that the UK Financial Reporting Council, the FRC, announced plans to require increased anti-corruption and bribery disclosures. Now, the UK Financial Reporting Council does regulate a limited number of UK entities. But I guess the thing that really struck me, James, was we often see one regulatory body put something new in place, try something different, and it really expands out to first on the prosecution or regulatory side, and then actually it morphs into a best practice on the civil side or the commercial side, my side of the table, as opposed to maybe your side of the table. So I was wondering if that would be any of the things that you have seen over the years, and I just see the growth and expansion of and the continued evolution of best practices from a variety of areas. And here we have a relatively small regulator in the United Kingdom, yet speaking directly to anti-corruption and anti-bribery.
Yeah, I think over the last couple of years, you've seen several efforts to try to increase anti-corruption related transparency and securities filings. Of course, we've had it's been very active in the mining industry, where several countries, including the United States at one point, tried to increase reporting requirements for mining companies to disclose some of the payments they were making. Of course, that kind of had a setback earlier this year in the United States, but we've seen Canada and several European countries pass those types of laws and regulations. I think this is another example of that. This was actually based on an EU directive that required large companies and financial institutions to disclose a whole range of matters, to provide, I'd say, probably more detailed disclosures in their securities filings regarding a large number of subjects that includes environment, human rights, and indeed, as you mentioned, Tom, and the reason it's in our newsletter, anti-corruption and anti-bribery matters as well. So I think there's sort of this push worldwide to try to bring more transparency to this area and to require publicly traded companies and other companies, large companies, to be more transparent when it comes to anti-bribery and anti-corruption matters.
James, we had a really interesting 3 months. We didn't get to the biggest FCPA case ever, the Telia company, because that happened in September. So I really look forward to visiting with you again. But as always, it's been a ton of fun, and I've learned quite a bit. I've been visiting with James Koukios, partner at Morrison Forster, on the firm's June, July, and August newsletters on the top 10 international anti-corruption developments. So, James, many thanks, and I look forward to seeing what you guys say about Telia in September.
Always a pleasure, Tom. Thanks for having me.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and also help get the word out about the only weekly FCPA compliance podcast. Also, if you have any questions, you can email me at tfox@tfoxlaw.com. The FCPA Compliance Report is a part of the Compliance Podcast Network, and I hope you will join me again next week when I have live reporting from the SCCE 2017 Compliance and Ethics Institute.